meditation, and in particular for the victims.
Je vous remercie.
Thank you.
Before turning to the substantive issues, I would like to provide you with some practical information. We also have to take some purely procedural decisions to ensure the proper functioning of the Assembly. Following a drawing of lots at the 13th meeting of the Bureau on 3rd of September 25, in accordance with the decision ICC-ASP/1/Decision 4 of 3rd September 2002, the delegation of Gambia will take the first place to my right, with the other delegations following in the English alphabetical order. Each state party will be allocated 2 seats with microphones and 2 seats behind. The other delegates from state parties are invited to sit in the seats at the back of the room or at the balcony. For observer states, as well as other observers, participants and guests, in accordance with rules 92, 93 and 94 of the Rules of Procedure, seats are also reserved at the back of the room. NGOs are invited to take their seats in the gallery. Distinguished delegates, in accordance with Article 112, paragraph 1 of the Rome Statute, states that are not parties to the statute but have signed either the statute or the final act of the Rome Conference may participate as observers in the Assembly. Observer states are allowed to participate in the deliberations of the Assembly but may not participate in the taking of decisions. Those states that are not parties to the Rome Statute and that have not signed the final act or the statute do not have observer status. Rule 94 of the Rules of Procedure provides that at the beginning of each session of the Assembly, the President may invite those states to be present during the work of the Assembly, subject to approval from the Assembly. I propose that the Assembly invite the following states which do not have observer status to be present during the Assembly's work: Bhutan, Democratic People's Republic of Korea, Equatorial Guinea, Eswatini, Lao People's Democratic Republic, Lebanon, Mauritania, Federal States of Micronesia, Myanmar, Niue, Palau, Papua New Guinea, Rwanda, Somalia, South Sudan, Tonga, Turkmenistan, and Tuvalu. May I take it that the Assembly wishes to invite these states to be present during its work? I do not see any objection. It is so decided. As already mentioned, seating has been reserved for observer states and invited states. Seating has also been reserved for NGOs invited under Rule 93 of the Rules of Procedure. Distinguished delegates, the provisional agenda is contained in document ICC-ASP/24/1, and an annotated agenda is contained in document ICC-ASP/24/1/Addition 1. May I take it that it is the wish of the Assembly to adopt the agenda as contained in document ICC-ASP/24/1? I see no objection. The agenda contained in document ICC-ASP/24/1 is adopted.
Excellencies, distinguished delegates, I have the honor of reporting to you on the activities undertaken by the Bureau of the Assembly this year. In order to save time, I will simply touch on some of the highlights that you can find in the full report, which will be included in the official documents of this session. I would like to begin by expressing my gratitude to our two vice presidents of the Assembly, Ambassador Michael Imbrancanu of Sierra Leone and Ambassador Margarita Kasangana of Poland. I'm grateful to them for their support at the Bureau and also in their role as the coordinators of the working group in New York and the working group in The Hague, respectively. I would also like to express my gratitude to the support my gratitude to the Secretariat for its support in my role as the President, its support to the Bureau, the working groups, and also all of those holding terms of reference in New York and in The Hague. We have recruited a director of the Secretariat with the aid of a recruitment committee. This was an important matter of business for the Bureau in 2025, and our new director, Madame Gabrielle McIntyre, assumed her new duties in May 2025, and I am very grateful to her for all of the assistance we've received over the past few months. Between the sessions, the Bureau held 16 meetings in order to assist the Assembly in upholding its responsibilities under the statute. In January 2025, the Bureau assigned to its working groups those tasks that had been assigned to them at the 23rd session of the Assembly. We also nominated facilitators and focal points for 2025, and the Bureau greatly appreciates their work. During the first half of 2025, the Bureau was involved in preparing for the extradition on examining the crime of aggression in New York from the 7th to the 9th of July 2025. The chair of the Working Group on Amendments, Ambassador Juan Jose Quintana of Colombia, played a vital role in preparing the bases for the discussions that took place at this extraordinary session. I would like to express to him my deepest gratitude for all of the efforts he deployed in order to make sure that that session would achieve a consensus. We now have a very clear roadmap for future discussions on these important matters.
The Bureau has regularly monitored the status of contributions to the budget of the Court and considered ways to better address the problem of outstanding contributions and arrears. In particular, the Bureau assigned the development of the criteria for the waiver of a loss of voting rights to the Budget Management Oversight Facilitation, noting the need to make progress on developing criteria. The Bureau recommended to the Assembly the granting of waivers to 5 states parties for the purpose of the special session. At its 16th meeting on 26 November 25, the Bureau recommended that the Assembly grant requests for waivers from the loss of voting rights to 1 state party at the 24th session of the Assembly, while recalling that the Budget Management Oversight has, throughout the intersessional period, worked on the development of agreed criteria for assessing such waivers in the future. I note that at this difficult moment for the Court, it is critically important that states parties pay their contributions as soon as possible. I would like to take this opportunity to express my appreciation to those states parties that have paid their assessed contributions to the 2026 budget in advance in response to the request made by the Registrar. I once more urge all states parties with outstanding contributions to make every effort to settle the outstanding balances as soon as possible. Throughout the intersessional period, the Bureau has been occupied with questions related to the investigations carried out by the Office of Internal Oversight Services, OIOS, into alleged misconduct by the prosecutor. As of today's date, the investigative fact-finding report is still pending, and the OIOS has consistently maintained that the investigation is a priority for it. At its 4th June 2025 meeting, the Bureau agreed on the establishment of an ad hoc panel of 3 external judges, each acting in a personal capacity. The panel will have an advisory role in relation to the Bureau and will focus on the legal characterization of facts in the OIOS report. The panel will operate independently, upholding due process, confidentiality and integrity. I note that the decision of the Bureau to appoint a panel of legal experts to undertake legal characterization takes into account discussions on the recommendations of the facilitation, on the review of the operational mandate of the independent oversight mechanism, and the study group on governance, which throughout the intersessional period considered the implementation of the independent expert review recommendation R108. I'm well aware that states have been frustrated with the length of this process, but I must underscore due process is and must remain the paramount consideration in the conduct and the conclusion of these proceedings. States parties will be advised in due course of the next steps in the matter. It is the responsibility of the Assembly under Article 112, paragraph 2 of the Rome Statute to consider, pursuant to Article 87 of the Statute, any question relating to non-cooperation. As requested by the Assembly, I have engaged throughout the year actively and constructively with all relevant stakeholders in accordance with the Assembly procedures relating to non-cooperation. At this 13th meeting of 3rd September 25, the Bureau considered the 24th of July 25 decision of the pretrial Chamber 1 regarding Hungary's non-cooperation in the situation of the State of Palestine. After hearing from Hungary's representative, the Bureau decided that the non-cooperation should be addressed at the 24th session of the Assembly. The Assembly decided at its 2024 session to include on the agenda of future sessions of the Assembly the consideration of non-cooperation issues arising during the intersessional period. The first special session on non-cooperation will have a particular focus on prevention of non-compliance through timely and effective consultations in accordance with Article 97. The protection of the court, its officials and those cooperating with it remains a top priority for the Presidency and the Bureau. It is essential that the Assembly strive to protect the court from attacks and ensure that it preserves its integrity, impartiality and independence. The strategy adopted by the Bureau on 29 July 22 for responding to attacks against the court, its officials and those cooperating with it was applied to confront attacks faced by the court during the intersessional period in 2025. On 23rd January 25, the Bureau issued a statement in support of the independence and impartiality of the International Criminal Court and reiterated its commitment to uphold and defend the principles and values enshrined in the Rome Statute and to preserve its integrity undeterred by any threats or measures against the court, its officials and those cooperating with it. I also issued personal invitation to the ministers of the 125 states parties to request their participation in the general debate of the Assembly, and I'm extremely grateful to record the participation of, I believe it's 25 ministers and deputy and vice ministers today. Together, further to the guidelines for enhancing the security of participants in the regular sessions of the Assembly of States Parties and its side events, which were adopted by the Bureau on 4th October 23, I continue to consult with States Parties, the Court and civil society regarding possible further measures which could be undertaken. I encourage a continued dialogue to further reinforce the guidelines going forward. Universality is essential for the effectiveness and legitimacy of the Rome Statute system. Striving for universality is a shared responsibility of both the Court and the Assembly, and it is crucial for upholding international justice and accountability. In light of this, the Presidency of the Assembly, in consultation with the Court, has made continued efforts to enhance universality with the assistance of the ad hoc country focal points on universality, the Netherlands and the Republic of Korea, as well as civil society, in particular parliamentaries for global action. Our sincere gratitude goes to all involved in this important endeavour, as their dedication and commitment are vital to ensuring that the Rome Statute system remains robust, inclusive and impactful on the global stage. I wish to take this opportunity to welcome the newest member of the Rome Statute system, Ukraine. The Rome Statute entered into force for Ukraine on the 1st of January 2025, representing a significant development towards universality. On behalf of the Assembly of the State Parties, I would like to congratulate Ukraine on this important step.
To conclude this oral Bureau report, I wish once again to express my deep gratitude to the vice chairs of the Assembly, the members of the Bureau, the facilitators, the focal points, as well as to all states parties. A special word of thanks also goes out to our invaluable partners from civil society and the dedicated staff of the court. Their tireless efforts, their support, their commitment are critical to the success of our common objectives. 2025 was a particularly difficult year for the court and for the Rome Statute system. It is essential for us to stand in solidarity with the court and with its staff. The Assembly of States Parties continues to support the work of the court and is steadfast in defending the principles of the values enshrined in the Rome Statute, since we are all aware that international justice is not only possible, it is imperative.
May I take it that it is the wish of the Assembly to take note of the oral report of the Bureau? I see no objections. It is so decided. The Assembly has thus concluded its consideration of Agenda Item 8. Distinguished delegates, we turn now to Agenda Item 9, Report of the Activities of the Court. The report is contained in document ICC-ASP24/11. We are honoured to have the Presidency of the Court, a Deputy Prosecutor and the Registrar present today. On behalf of the Assembly, it gives me great pleasure to extend to them a warm welcome and to assure them of the continuing support of the Assembly in the discharge of their respective responsibilities. I will invite the President of the Court, Judge Tomoko Akane, and Deputy Prosecutor Monsieur Mandiam to address this plenary today. The Registrar, Mr. Osvaldo Zavala-Hilaire, will deliver remarks to the Assembly when we take up Agenda Item 12, consideration and adoption of the budget for the 24th financial year. I shall first give the floor to the President of the Court, Judge Tomoko Akane.
Madam President of the Assembly, esteemed delegates, civil society representatives, ladies and gentlemen. I'm honored to address this 24th session of the Assembly of State Parties on behalf also of First Vice President Aitara, Second Vice President Lapine Gansu, and the whole court. When I reported on the activities on the International Criminal Court before the United Nations General Assembly on 11 November, the President of this General Assembly, Ms. Annalena Baerbock, stated that the court does not, on its own behalf, but in defense of the principles of the United Nations Charter to protect us all from the gravest crimes, State parties, therefore, cannot remain silent. Indifference will lead to a world in which might makes right. We are profoundly grateful to those state parties which have been actively supporting the court in the last months, openly or discreetly, lending political backing as well as material aid through their companies which make the operations of the court possible in the current circumstances. This presidency has sought to maintain a dialogue with as many states as possible and has traveled to capitals from all regional groups during the past year. We are particularly grateful to those states that have welcomed us and enriched our work with their views. We will continue our diplomatic outreach in the months to come. The values underlying the Rome Statute, as articulated the preamble, are common to the entire humanity. Committing to universality is therefore vital to reaffirm those values and thus to strengthen the court's legitimacy. The court will continue its effort to increase the number of state parties and appreciates the commitment of our civil society partners in raising awareness and promoting universal ratification. I believe the issue of regional representation is a key in this respect, and I encourage this Assembly to continue actively discussing this matter. The Court, for its part, will continue with regional seminars and other universality initiatives. Madam President, last year I have recalled before its distinguished Assembly the looming dangers for this noble institution: international law, international justice, and eventually humanity. I have also pledged on behalf of all women and men who work for the court that we would have never given up to coercive measures, threats, sabotage, or outrage. Both the prediction and the proposition came true. Today, 9 elected officials, including 6 judges, have been designated for sanctions by the United States, alongside with terrorists and drug traffickers. Their personal and family lives are being unsettled, and their ability to conduct financial transactions disrupted, also in the territories of state parties, including in Europe. 9 elected officials, including 1/3 of the judges, as well as the totality of the ICC presidency, are subject to arrest warrant issued by the Russian Federation. Just a few days ago, it was reported that the investigative committee completed its investigation and placed these elected officials on the wanted list. As far as we know, these officials have been indicted and arrested in absentia, and hearings are being held in their absence. This will have an obvious impact on their personal security. These coercive measures plainly aim at undermining the existence and the reputation of the court and integrity of its judicial proceedings, and the safety and serenity of the officials. The response of the court has been absolutely unambiguous. Our independence and impartiality are our polar stars and remain unaffected. Our loyalties are only with the Rome Statute and international law. The court has taken several measures to mitigate the impact of these coercive measures and strengthen our resilience. Most of these measures remain confidential to ensure their effectiveness, but I would again like to thank states that are working with us to find solutions. Let me be explicit. We never accept any kind of pressure from anyone on issues of interpretation of the statutory framework and adjudication of cases. Any dispute concerning the judicial functions of the court shall be settled by the decision of the court, reads Article 119 of the Rome Statute. We encourage states parties to resort to timely consultations under the statute if they identify problems in the execution of requests for cooperation. The court also recalls that the Rome Statute provides for legal avenues for states to pursue the value underlying the Charter of the United Nations without infringing on the independence and impartiality of the court. Madam President, the achievements of the court this year speak for us unequivocally. In the face of the unprecedented levels of workload and amidst the attacks against it, the court is acting expeditiously and effectively in all stages of proceedings, investigations, pretrial, trial, appeals, and reparations. I pay tribute to our staff in chambers, the OTP, and the registry for these results. Everyone is acting with dignity, resilience, professionalism, and abnegation. We are all bound together by the awareness of the gravity of the moment and the firm determination to protect at any cost the values on which we have solemnly sworn. We consider ourselves accountable to any and all victims, particularly children and women. We are committed to our missions and thus the duties enshrined in the Rome Statute. I have provided the full overview of the court's activities to the Assembly in writing. I am only mentioning some key developments. The pretrial division has issued numerous arrest warrants of great importance and complexity, emanating from several situations across continents. Most of the arrest warrants remain under seal until the judges decide differently. In any criminal court, confidentiality is key for orderly conduct of the proceedings. The seriousness of the judicial function and the appearance of independence and impartiality. A new regulation recently adopted by the plenary of the judges, which standardizes the existing practice of pretrial chambers, provides that all applications for arrest warrants or summons to appear must be classified as secret or under seal and cannot be revealed. It is for judges to decide on a case-by-case basis whether to make the issuance of arrest warrants public, including in order to interrupt criminal conduct, deter other crimes, or maximize opportunities for arrest. In the Sudan-Darfur situation, which was referred to the court by the United Nations Security Council, the chamber has convicted Mr. Abdurrahman, a leader of militia, for 27 counts of crime against humanity and war crimes. This case concerned crimes committed in an armed conflict in 2003 to 2004, which have taken the lives of and forced the freeing of hundreds of thousands of civilians, including children. Many of those who are displaced were unable to return. 1,600 victims have participated in the trial. We trust this judgment will light a little spark of hope for the many who are suffering in the ongoing conflict at this very moment. The case against Mr. Joseph Kony in the Uganda situation has marked the first instance in absentia confirmation proceedings at the court. In the situation in the Philippines, the surrender of Mr. Rodrigo Duterte was the first from the Asia-Pacific region. A new surrender in the situation in Libya is imminent, as if realized, a new confirmation proceeding will commence. The court acknowledges with gratitude the cooperation in the arrest and surrender of suspects of the concerned states. When states cooperate with the court, regardless of whether they are parties to the statute, they nurture justice, the rule of law, and the values that bind humanity together. Madam President, the court is committed to improve its workplace culture, and the leadership is applying zero-tolerance policy against harassment, including sexual harassment, as well as discrimination and abuse of authority. The presidency and the plenary of the judges, as well as the court as a whole, take this issue with absolute seriousness. Where we had authority in line with the legal framework, we have held accountable those who needed to be, including an elected official this year, in order to protect affected staff members swiftly, impartially, and in compliance with due process. The court is also working to improve its internal systems and processes, as well as on the Charter of Ethics. We have also released court-wide core values. The court also appreciates the leadership of the presidency of the ASP with the state parties in line with their authority on the matter before it. Everyone must be accountable, elected officials and staff. This, I strongly believe, is essential to protect the court's resilience and credibility. Staff also deserve that any misconduct or unsatisfactory conduct is dealt with appropriately in line with the applicable framework. I would like to also encourage staff to continue focusing on their core duties with serenity, with trust in the applicable processes. Madam President, in my office at the court, I have a piece of calligraphy with the words of Lao Tzu, a Chinese philosopher from the 6th century BC, which roughly translates to, "A grand image does not have form." It means that grand things do not have a shape which our eyes are able to see. We humans tend to focus on things that are immediately before us, and in doing so, we neglect looking at the bigger picture or matters that are of fundamental significance. I respectfully invite all of you to look at the grand image that underpins our work, the cause of humanity and justice, which has no boundaries. They are universal. Now more than ever, we must turn our eyes to the unseeable suffering of countless innocent civilians. We must redouble efforts to defend human dignity. I call on states, including states not parties to the statute, and all persons to stand united with a code in defense of humanity. Organizations of civil society have accompanied the code hand in hand since the very beginning of the 50-year-long process that has led to 17th July 1998 in Rome. We need you more than ever. Your thirst for justice is the thirst of humanity. We know that the current circumstances are also affecting you, but we beg you to continue working for our cause. Better times will come. To borrow the words of Nelson Mandela, a winner is a dreamer who never gives up. We must remember that we are all working for a cause, a grand, albeit unattainable cause. We must continue to work for this cause, to provide hope for humanity, and to realize a more just world that is free from atrocities, where future generations peacefully coexist. Thank you very much.
I thank President Akana for her powerful and timely statement. I now invite Deputy Prosecutor Mam Mandaye Nyang to address the Assembly.
Madam President of the Assembly, Madam President of the Court, Honorable Judges of the Court, Mr. Registrar, Excellencies, distinguished delegates, dear colleagues, ladies and gentlemen. It's an honor for me to take the floor here, Madam President of the Court, as Deputy Prosecutor, taking over as ad interim head of the OTP, and also on behalf of Nazat Shamin Khan, Deputy Prosecutor of the Court. Without a doubt, this year has been a year of immense challenges. But I am also firmly convinced that this year has also given us many reasons to believe that together we will be able to bring to bear the essential promise at the heart of the Rome Statute. Over the course of this year, we found ourselves facing two opposing trends in our work and our commitment. Firstly, for those who are victims of crimes under the statute, and on the other hand, powerful stakeholders who have been undermining our work and what we do to eradicate impunity, and that we will not accept. So I wanted to start by offering you a message of hope and a solemn appeal for our common work. And I would like to quote a survivor of the atrocities in Darfur, who said, "I am bringing my voice here before you, but also the voices of all Darfur refugees, wherever they are around the world. I have come to tell you that we aspire to peace, we demand justice. We want that all of those who turned our lives into a series of humiliation, suffering, and fatigue answer for their crimes. We want those who shattered our lives and compromised our children's future be ultimately judged. That's enough. The time has come. So that is what the victim of Dartour said. And these words, I think, encapsulate the quintessence of what the ICC embodies. That there can be no other path towards justice. It also reflects the accounts and emotions of many victims and survivors with whom we speak. Victims whose trust in the law remains intact, even when the world around them appears to be crumbling. They pay tribute to the witnesses who very often have, despite their immense sacrifices, chosen truth rather than silence, justice rather than fear. Their courage is a powerful light in the dark, a force that inspires and that raises us all up. They are the very raison d'etre of the lawyers, the legal experts, the human rights defenders from all corners of the world who work ceaselessly for justice. Sometimes under threats, sometimes without recognition, but always with an unwavering conviction and a deep faith in the ideals of justice and law. These words remind us that the court is not just some abstract institution. It can be a veritable lifesaver. Even in our darkest hours, these words and this court embody the promise, the rights of individuals that each human life, regardless of where the person is, has a value. Madam President, Excellencies, ladies and gentlemen, in the world before us today, threatened by conflicts, gangrenous with disinformation, made fragile by impunity, the International Criminal Court is standing strong and is more relevant than ever. From Ukraine to Darfur, from Palestine to Venezuela, from the Democratic Republic of Congo to the Philippines, even through to Libya, voices are growing and the calls are becoming all the stronger. Our office has had an unprecedented influx of submissions. With all of these communications, a clear message comes through it all. These communities are calling on us. They are looking to us, and they expect of us our acknowledgement and responsibility. What they are calling for is that justice be not some ideal far off and intangible, but rather a material reality. We are fully aware that these expectations are very broadly shared by many of you gathered here today. States parties, civil society organizations and partners, you who with the strength and consistency have called on our office to take action, to undertake our investigations and make justice a reality, including in the most difficult of contexts. But if this intensification of workload for our office reflects a dire landscape with violations and suffering on the rise, it also means that there is a message of hope. It means that there is recognition by the people affected that the ICC is a trustworthy institution to which they can turn in their time of need. But in parallel with this unprecedented amount of requests, we've had to deal with coercive measures that have been trying to undermine the independence of our action. So as over this week we undertake our collective deliberations, it's important to be frank and recognize that the sanctions that have been imposed on the court, as Madam President just mentioned a moment ago, that these will have negative repercussions. Firstly, they lead to uncertainty and concerns and place pressure on staff who are affected by them. And this coercive action also extends to our partners in civil society, who are there as true partners and share this feeling of duty and solidarity. Now, it is true that defending justice often does require personal sacrifices, but this is also an imperious call to perseverance. Because if those who are pursuing justice become targets, then it's the victims themselves that are actually under threat. And with those victims, the very idea of universal responsibility. So I want to be very clear. This pressure, be they personal or institutional, have rather strengthened instead of weakening our conviction in the noble mission of this court. Yes, they are difficult times, but this is a challenge for which we are ready and that we shall face together and with determination. And personally, I have borne witness to the integrity and courage of my colleagues who have continued their work regardless. I've also seen that with each mission, with each meeting with our partners, that their commitment and the expectations that are sometimes silent but unwavering, we know that we must not yield. Because justice, even when it is contested, needs to remain strong and unaltered. It is the very foundation of our commitment. It is the compass that guides our action. And it is the promise that we make to the world, that of never yielding in the face of challenges, but rather to stand tall with consistency, with honor, so that the law will triumph.
Excellencies, ladies and gentlemen, in that spirit of common purpose and drawing on the continued hope shown by so many of you this year, the office has ensured that 2025 was a year of real progress, a year that demonstrates what determined, principled action together with our partners can achieve. Building on the unprecedented engagement we have received from affected communities, a record number of arrest warrants have been issued or executed. These have included an essential recognition of the nightmare faced by women and girls in Afghanistan every day. And across the situations we address, we are delivering concrete progress through focused and effective investigations, drawing on our cooperation with you. Based on this action, we have seen landmark arrests in this year, including that of Rodrigo Duterte, former president of the Philippines, now before the courts on charge of crimes against humanity, and Khaled Ali El-Ishri, arrested in Germany for crimes in Libya's detention facilities. And I wish, after Madam President, to express our thanks to our registry, first and foremost, our registry colleagues in particular, for the strengthened coordination that has led to such results, as well as to German authorities for their diligent and ongoing efforts in implementing this warrant of arrest. In the courtroom, we have also reached important milestones. The conviction of Ali Abdurrahman marked a turning point as the first conviction in relation to crimes committed in Darfur, the first conviction pursuant to a referral made by the United Nations Security Council, and the first at the ICC for gender persecutions. This is a limited, still insufficient, but essential moment of recognition for the people of Darfur. Most importantly, it sends a clear message. The message that those on the ground in Darfur who seek to inflict suffering should know that the sense of impunity they feel at this moment will not last forever. The office is working intensively on recent events in El Geneina, Al Fasher, and other locations to ensure that perpetrators are held to account. Deputy Prosecutor Nazar Khan and I are personally committed, in particular, to ensuring that the sexual violence and broader gender crimes being committed in Darfur are thoroughly investigated. Other landmarks have also been achieved. Last month, the ICC chamber confirmed all 39 charges brought by the office against the Lord Resistance Army commander, Joseph Kony, following the first hearing in absentia by this court. That was in September. And earlier this year, the conviction and sentence of Alfred Yakatom and Patrice Edouard Ngaisona in the Central African Republic for war crimes and crimes against humanity, here again reaffirm that justice, that may take time, but it does come. Each of these achievements attained through our cooperation with all partners demonstrates that despite the headwinds we face, this court is working. These outcomes also demonstrate the living relevance of the Rome Statute. They show how our renewed policy framework on gender persecution, gender-based crimes, crimes against and involving children, and slavery crimes, all of those policies, so this framework is producing now tangible results in court. With the launch of our policies on environmental damage and cyber-enabled crimes under the Rome Statute at this Assembly, the Office now concludes a significant phase of thematic policy development, one that strengthens the Rome Statute ability to address the evolving threats of our time and allows us to partner in ever-evolving ways with organizations at national and regional level. We are grateful to state parties who have contributed to the realization of these policies and underlined their willingness to support next steps in their implementations. We are also seeing positive developments in widening circles of cooperation, even in places where the doors once seemed closed. There have been signs of openness and constructive engagement from Sudan and Libya, both states not party to the Rome Statute and situations referred to by the UN Security Council. In both contexts, channels of communications and cooperation that had long been constrained are beginning to re-emerge. These developments, while fragile, mark a positive shift and an important opportunity to establish partnerships and strengthen accountability efforts in two situations that have tested the resolve of the international community for over a decade. Similar momentum has also been seen in relation to other states not party to the Rome Statute, who have increasingly engaged with the office to enhance their knowledge and understand how we can work together. There is a real, if nascent, opportunity in this moment to widen our engagement to strengthen universality. This year, the office has also strengthened its approach to positive complementarity, recognizing that sustainable justice depends on national ownership, and emphasizing that the office wishes to serve as a partner with all states in pursuit of accountability. This renewed approach has allowed us to deepen our engagement in relation to domestic processes in Colombia, the Central African Republic, the DRC, Ukraine, and Guinea, reinforcing judicial capacity, exchanging knowledge, and empowering national jurisdiction to act. The strengthening of this partnership and those in other situations will remain a key priority in the coming year, in line with our policy on complementarity and cooperation. In Venezuela, however, following sustained engagement, we have determined that real progress on complementarity has still been a challenge. Accordingly, and mindful of the need to effectively manage our limited resources, we have decided to close our in-country office in Caracas. Our investigation in this situation remains focused and active, based on the work of our dedicated unified team, together with our partners and guided as always by the evidence and the law. In the office workplace, let me just say a few words in that office workplace. Within our own institution also, we have recognized the need to place further emphasis on accountability and well-being. The past year has brought legitimate scrutiny to our internal culture. The office has taken this concern to heart we have sought to ensure a calm space for our dedicated staff, while the independent process established by the Assembly being conducted by the United Nations Office of Internal Oversight Services, while this process has been ongoing. The resolution of this issue remains a matter of urgency and priority, as we as Deputy Prosecutor, we remain personally committed to fostering a workplace anchored in respect, dignity, equality, and trust. Those values that must underpin any institution that seeks to deliver justice for others. Creating a safe, respectful, and inclusive workplace is not just a strategic priority. It is a deep commitment shared across all levels of this office. Listening to staff, legitimate concern, learning from feedback, and embracing bottom-up proposals will be key to the journey ahead.
Madam President, distinguished delegates, ladies and gentlemen, we are entering a new institutional era under the ICC Strategic Plan for 2026-2029. And as such, all of the court's organs, as well as the Trust Fund for Victims, stand united firmly on the principle of the one court principle. This has enhanced our collective capacity to act in a consistent, swift, and impactful manner. In certain areas, it really is the result of the constraints that we have to contend with. We are subject to external pressure, and that has actually, in turn, enhanced our capability to stand united and to get the job done. I'm grateful to all of us gathered here today, and I know that we all stand united in order to rise to the challenges that are looming on the horizon. We have made undeniable progress in our work, and the demand to take action has never been higher. But we have to admit that within certain circles of the international community, there are signs of wavering, signs of being tired of the ICC. And this reveals a worrisome fear for the practice of consensus, something that has been a long-established principle when it comes to the fundamental rule of law in the international order. We must contend with these trends face-on, with honesty and with determination. And we have to do this together. Now, we can do this by demonstrating through the sheer force of our actions that the action of the ICC is something that only represents value for the victims of crimes, but also for the international community as a whole. Whenever there are attempts to undermine our work, we have to stand up and say loud and clear that the obligations that stem from the Rome Statute remain fully applicable. And I would call on all of us to renew our energy, our dedication to our mission, to execute warrants, to share information, and protect witnesses. This is not something that is an act of generosity. These are obligations, legal obligations, and they are essential to the credibility of this collective system of justice. The ultimate beneficiaries are each and every one of us. There are forces trying to fragment us. But your presence here in The Hague, with all this large number of states parties, of observers, representatives of victims associations, civil society organizations, all of this is a very strong declaration of faith. Faith in international criminal law, in international criminal justice, and in the perennity of the institutions established under the Rome Statute. The International Criminal Court was never going to be an easy task. It was established to respond to an imperative need, the need to take action when faced with the most heinous crimes, those that affect all of humanity. And for those of us who know this firsthand, this mission is something that also is a personal vocation. It's a personal dedication to make sure that law remains something that can protect those who have nowhere else to go. So our state, civil society, victims, and the court, we stand here together with a renewed conviction. This is not something that's a luxury as we try to seek peace. It really is the very foundation of any peace. As the survivor of Darfur that I quoted earlier recalled, the edifice of our joint endeavor rests on this categorical need for justice to be provided to those who are the victims under the Rome Statute. These are the darkest chapters in human history, and they cannot be read through the prism of despair. Rather, we should look at this from the prism of resilience, fraternity, and, in fine, the very reaffirmation of our shared humanity. Faced with threats, faced with disinformation, there is one thing that remains certain. We shall remain firmly committed and determined to defend this fundamental truth. All lives have equal value under international law. Thank you very much for your attention.
I thank Deputy Prosecutor Mamman Yang for his informative and relevant statement. I propose that the Assembly take note of the report of the International Criminal Court contained in document ICC-ASP24/11. I see no objection. It is so decided. I would like to take this opportunity to express my gratitude to the Court for the support it has provided to various mandates and initiatives of the Assembly, to the Bureau and its working groups, and to me personally. The Assembly has thus concluded its consideration of Agenda Item 9. Distinguished delegates, let us now turn our attention to Agenda Item 10, Report of the Board of Directors of the Trust Fund for Victims, the report on the activities and projects of the Board for the period of 1st July 24 to 30th June 25 is contained in document ICC-ASP24/14. And I now have the honor to give the floor to Mr. Andres Parmas, Chair of the Board of Directors of the Trust Fund for Victims.
Dear Madam President, Your Excellencies, court officials and delegates, members of civil society organizations, members of communities affected by the crimes under the jurisdiction of this court. It is an honor to address you. We are gathered at a critical moment when, on the one hand, children, women and men continue to be victims of massive and unimaginable atrocities, and on the other, the court and the entire foundation
of international criminal justice are facing unprecedented attacks and existential threats. At this time, we must stand together and remember why we are all here. The ICC was created to bring justice and to redress the harm that the most serious crimes cause on individuals, on communities, and on the whole nations. In this endeavor, the reparative work of the ICC through the Trust Fund for Victims ensures justice to victims. The judicial proceedings of the court have advanced and they have expanded, and thus the work of the Trust Fund needs to be understood by our critics and our supporters alike as being at the heart of the aspirations of the Rome Statute. For too long, efforts of redress to victims have been treated as an add-on to accountability, almost as an afterthought in our words and deeds about the ICC internationally and domestically. Programs for the benefit of victims have received the much appreciated voluntary financial support from numerous states parties. But still, the number of contributing countries and the volume of this support is too little to do justice to the lofty ambitions of those who have adhered to the aspirations of the Rome Statute. Your government established this court because nations learned the hard way that the lack of accountability threatens peace and it threatens security, and that lack of redress and reparation repeat cycles of violence. The Board of Directors has reported to the Assembly what redress has meant in practice. Nearly 78,000 individuals have benefited in the past 5 years. Every figure in our reports, they represent a person, a life, a former child soldier seeking to rebuild a broken childhood, a survivor of sexual violence reclaiming their sense of safety and dignity, a community struggling to preserve its culture and way of living after devastation, and many others. Nearly 3/4 of participants in our programs that are presented in the report refer to women and girls. These women are not merely beneficiaries. They are survivors. They are caregivers and agents of resilience, holding families and communities together despite immense trauma. The Rome Statute system exists for them. So when the court is supported and when victims experience reparative justice, you are enabling not only the upholding of norms, but also healing. You are enabling hope that devastation may have an end. Together, we are building a narrative of hope and our common future. In approving the budget for the court to do its work, in protecting the court from threats, and in providing necessary contributions to the Trust Fund for Victims, you are declaring to your own nations and to the world that norms and people matter, that security matters, and that peace matters. The court and the Trust Fund have done the work. With successful convictions of the most responsible perpetrators of mass crimes, the continuous delivery of reparations and programs of assistance, with economic prudency and unstoppable determination for business continuity in the face of serious threats. This work resulted, as is visible in the report of the Trust Fund for the Victims presented to the Assembly, that in 2024, with your support, we reached the highest level of contributions, nearly 6 million euros, a historical high. However, I regret to report that the outlook for 2026 is dire. The Trust Fund for Victims anticipates a sharp decrease in income this year, possibly near to merely 25% of what was received last year. Despite these limitations, through radical and difficult prioritization decisions, the Board of Directors is pleased to announce that the Trust Fund for the Victims will complete the second reparations program in the Almaty case and will continue delivering reparations in the Lubanga and Ntaganda cases. Also, the Trust Fund has received the first pledge for resources to launch the reparations program in the Ongwen case. This first pledge from the ODA eligible funding from Finland, together with the allocations that the board made from contributions in 2024, will shortly enable the announcement of the first complement to the Ongwen reparation order, and to launch the initial phase of the program, even if only modestly. The Board of Directors has reported to the Assembly on the substantive measures to enhance the visibility of the Trust Fund and of the fund mobilization strategy of the fund, which was consulted at the Hague Working Group level throughout this year in a process nourished by the active engagement of numerous states parties under the facilitation and leadership of His Excellency Vusi Madonsela, Ambassador of South Africa to the Netherlands. Looking ahead, the strategic plan of the ICC for the 2026-2029 period will contribute to the reinforcing the work of the Court and the Trust Fund on Victims by delivering prompt and meaningful measures of redress, in line with the vanguard reparation principles issued by the judges according to the Rome Statute Article 75. In closing, the Board of Directors wishes to recognize the work of the ICC Presidency, the judges, the deputy prosecutors and their office, as well as, very importantly, of the essential support the Trust Fund for Victims has received from the registry. The Board of Directors acknowledges the trust that affected communities have put in the Court and the Trust Fund for the Victims as they are engaging in the programs. The Trust Fund is both humbled and driven by our service to them. Dear Excellencies, justice, very much like history, is made by the acts of individuals. This includes activists, human rights defenders, academia, and the staff of this court. Centrally, it relies on you, delegates from states parties, who have the power to shape through this assembly a pathway towards justice and redress for the benefit of all humanity. I thank you very much for your attention.
I thank Mr. Parmas for his statement, and on behalf of the Assembly, I ask that he convey to the distinguished members of the Board the appreciation of the Assembly for their tireless efforts and commitment to provide effective remedy to victims. I propose that the Assembly take note of the report of the Board of Directors of the Trust Fund for Victims contained in document ICC-ASP24/14. I see no objection. It is so decided. We have thus concluded our consideration of agenda item 10. The Assembly will now begin its consideration of agenda item 5. In accordance with Rule 25 of the Rules of Procedure, a Credentials Committee consisting of representatives of 9 states parties shall be appointed at the beginning of each session on the proposal of the President. After broad consultations with states parties, I propose that the Credentials Committee consists of the following states: Costa Rica, Czech Republic, France, Germany, Norway, Panama, Slovenia, South Africa, and Uganda. May I take it that the Assembly agrees to proceed accordingly? It is so decided. I wish to remind representatives that pursuant to Rule 25 of the Rules of Procedure, credentials shall be submitted to the Secretariat, if possible, not later than 24 hours after the opening of the session. Credentials shall be issued by the head of state or government, or by the Minister of Foreign Affairs, or by a person authorized by either of them. Before we move to the next agenda item, I wish to indicate that the Bureau decided to recommend that the Assembly appoint Ms. Sakura Ozaki of Japan as rapporteur for the 24th session. Does the Assembly agree to appoint Ms. Sakura Ozaki as rapporteur for the 24th session? I see no objection. It is so decided. I congratulate Ms. Ozaki on her appointment and thank her for her willingness to take up this responsibility on behalf of the Assembly. Distinguished delegates, we shall now turn to agenda item 6, Organisation of Work. The Bureau has considered the programme of work, which is reflected in the ASP journal dated 30th of November 25. The Bureau proposes that this programme form the basis of our work for this session. I trust that you will all understand that the programme of work may be subject to modification depending on the progress attained on the different items. I would ask each representative to ensure that she and he arrives on time to the meetings in order for the Assembly to complete its consideration of all items on its agenda for the 24th session. May I take it that the Assembly decides to adopt the programme of work reflected in the ASP journal dated 30th November 25? I see no objection. It is so decided. As proposed by the Bureau, the Assembly will meet in plenary session and will hold informal consultations on some key issues on which decisions must be taken. At its 3rd December 25 meeting, the Bureau recommended that the following representatives be appointed as coordinators for the 24th session. For the working group on the programme budget, is Ambassador Jorge Carvajal San Martin from Chile. For the informal consultations on the Omnibus resolution, Ms. Beatrice Maillet of Canada. May I take it that the Assembly wishes to proceed on this basis? I see no objection. It is so decided. I congratulate Ambassador Jorge Carvajal San Martin and Ms. Beatrice Maillet and wish them every success as they carry out their responsibilities. I assure them that they can rely on the Bureau to provide any guidance that may be necessary. The Assembly will now turn to agenda item 4, States in Arrears. According to Article 112, paragraph 8 of the Rome Statute, a state body which is in arrears in the payment of its financial contributions towards the cost of the court shall have no vote in the Assembly and the Bureau if the amount of its arrears equals or exceeds the amount of the contributions due from it for the preceding 2 full years. The Assembly may nevertheless permit such a state party to vote in the Assembly and in the Bureau if it is satisfied that the failure to pay is due to conditions beyond the control of the state party. The Secretariat sent a note verbal dated 21st October 25 to all concerned states via their United Nations missions as well as their embassies in The Hague and Brussels, informing them that they were in arrears and stating the minimum payment required to avoid the application of Article 112, paragraph 8 of the Rome Statute. In accordance with information provided by the court, it would appear that Article 112, paragraph 8 of the Rome Statute is currently applicable to 12 states parties. I have been informed that one state party, the Central African Republic, has paid its assessed contribution so that the provisions of Article 112, paragraph 8 are no longer applicable to this state. I thank the Central African Republic for paying its contribution to the budget of the court. I wish to note that the Bureau, having received a request for waiver from the loss of voting rights for the 24th session of the Assembly from the Bolivarian Republic of Venezuela, decided to recommend that the Assembly grant this request for a waiver from the loss of voting rights at the 24th session. At the same time, as mentioned in my oral report, the Hague Working Group has discussed the issue of developing criteria for the grant of waivers in the budget management oversight facilitation during the intersessional period. A draft resolution was approved by states parties on the procedure and criteria for the waiver of the loss of rights. If this resolution is adopted at the current session, the procedure to be agreed for criteria for the grant of waivers for the loss of voting rights will apply to all future situations of voting by the Assembly. Does the Assembly agree to grant the request for waiver of the loss of voting rights which it has received? Thank you. It is so decided. We will proceed accordingly. We have 3 countries requesting the floor after taking this decision, and we will give first floor to Argentina.
Señora Presidenta.
Madam President, thank you for giving me the floor. Allow me to wish you a very fruitful session. You know that you can count on the support of Argentina. Argentina requested the floor and just to disassociate itself from the consent because we want to reiterate what we've already said at the 23rd session of this Assembly concerning the situation of Venezuela. The situation of Venezuela has further deteriorated since July 2024, and it requires urgent attention. We do note that the registrar back in 2021 raised the alarm over the situation in Venezuela, but little progress has been made. There have been arbitrary detentions and various crimes against humanity that have been perpetrated by the Venezuelan regime. And there has also been arbitrary orders of arrest. And we do not wish to block the consensus, but we do think that in the situation of Venezuela, we do think that Venezuela is a member of this Assembly, and we wish to see a general procedure instituted for when it comes to states in arrears at the ASP. Allow me to underscore the fact that we do not wish to be part of this decision, and we feel that this should be duly reflected in the Assembly's summary records. Thank you very much.
I thank the representative of Argentina and give floor to Canada.
Thank you, Madam President. The Budget Management Oversight Facilitation has given us a constructive space to engage on the issue of waivers under Article 112, Paragraph 8 of the Rome Statute, an area on which Canada has worked collaboratively with states parties over several years. We warmly congratulate Ambassador Tisalu for his skillful leadership of these discussions this year. We welcome the newly found consensus to clarify the framework and criteria to assess waiver requests when a state's party's inability to pay arises from conditions beyond its control. This is an important development. Such clarity will strengthen confidence in the integrity and fairness of the process. States parties must ensure that the court receives its full budget allocation. This begins with full and timely payment of assessed contributions. This is essential to safeguard the court's ability to carry out its mandate effectively and to improve its resilience, which are front of mind as we reflect over the next 2 days on how states parties can take concrete measures to support the court at this time. In this regard, we are encouraged that the court received over 90% of its assessed contributions this year, a testament to the collective commitment of states parties. Canada remains committed to working constructively with all states parties to uphold the financial sustainability and independence of the court. Thank you.
I thank the representative of Canada and give floor to Japan.
Thank you, Madam President. Japan welcomes the consensus achieved on the procedure and criteria on the waiver of the loss of voting right after months of consultations held in the BMO facilitation under the leadership of Ambassador T. Saru of Estonia. Japan sincerely looks forward to the implementation of a structured, transparent, and objective waiver procedure going forward. Thank you very much.
I thank the statement by Representative of Japan and give floor to Venezuela.
Gracias, señora.
Thank you very much, Madam Chair. Since it's the first time I'm taking the floor, allow me to extend our greetings to one and all, wish you fruitful proceedings and greetings to one and all in the floor. We would like to thank you for the solidarity of all the members of the Assembly with this maintenance of our voting rights because of the situation that is beyond our control. And rest assured that once we are able to re-establish normal relations, we will be in a position to honor the debt that we have to this institution. Venezuela's commitment has been clearly manifested by its active participation in the role of this institution, and we wanted to express our satisfaction with the flexibility that has been accorded to us, and we welcome the clarification of the framework for waiving arrests going forward. We are sorry to see that the kinds of coercive measures imposed on my country are also being imposed on the country. We also wanted to respond to the government of Javier Milei, which unfortunately has taken this opportunity to politicize the discussions here. We do think it is not a timely moment to politicize the work of this and hold itself up as a defender of human rights. If Milei and his government wish to talk about a regime of my country, then they should look at their own first. And in July, in 5 UNSC resolutions, Argentina has taken steps that go against this. On the 20th of November, there was a decision on the torture of individuals, and during that session of the United Nations Security Council, we think that Milei's government voted against the consensus and against resolving a situation. In this regard, we would like to invite Argentina and other states parties to focus on the work at hand of this court rather than politicizing matters, so that we can continue working on, in a spirit of solidarity, on the major issues before us. Thank you very much, Madam President, and thank you very much for your time. We should like also our reply to be listed in the summary records of these proceedings. Thank you.
I thank the representative of Venezuela, and I give now floor to Madagascar.
Bonjour.
Good morning. First of all, we should like to ask whether Madagascar is one of the countries that has not got a right to vote here, because it was only the 26th of November that we were able to deal with the issue, because we had a change of government, and from 2024 we had some assessed contributions that were outstanding. We just wanted to be sure that now Madagascar is one of the states parties that is indeed accorded the right to vote at this session. Thank you very much.
I thank the representative of Madagascar for their point of clarification, and the list that I have in front of me does not list Madagascar as a country in arrears, and I can thus confirm that Madagascar holds the voting rights as other states parties. And I would like to give floor then to the representative of Argentina.
Muchas gracias.
Thank you very much, Madam Chair, for giving me the floor again. I just wanted to say that my delegation rejects all of the allegations that have just been leveled at it by Venezuela. Argentina has always been understanding of the financial difficulties imposed on other member states at this assembly, but we cannot turn a blind eye to the crimes that are being perpetrated in that country. And the attitude of Argentina needs to be upheld here in this assembly in line with all of our commitments under international law, and we reaffirm before the court that urgent and concrete measures need to be taken to resolve the situation in Venezuela. Thank you very much.
I thank the representative of Argentina, and I would like to stress once again the importance of ensuring that the court is provided with necessary financial resources. I encourage all states parties to pay their assessed contributions in full and on time, or in the event of pre-existing arrears, immediately, in accordance with Article 115 of the statute and Rule 105.1 of the financial regulations and rules. Distinguished colleagues, let us now turn to agenda item 11, election of the members of the Committee of Budget and Finance. Under this agenda item, there are 3 separate elections. First, election of 6 members of the committee. The 6 vacancies that will arise on the committee on the 31st December 25 upon the expiration of the terms of office of 6 members are as follows. African states, 1 seat; Eastern European states, 1 seat; Latin American Caribbean states, 1 seat; and Western European and other states, 3 seats. At its 6th meeting on 12 March 25, the Bureau fixed the nomination period to run for 12 weeks from 2nd June to 24th August. At the end of that period, since the number of candidates remained less than the number of seats, and in accordance with resolution ICC-ASP1/resolution 5, the nomination period was extended to 11th September and subsequently to 30th September and 20th October 25. As regards the election of members from 4 regional groups of states parties, since the number of candidates corresponds to the number of vacancies in the Eastern European, Latin American and Caribbean, Western Europe and other states group, and at its meeting on 8th October 25, the Bureau decided to recommend, pursuant to resolution ICC-ASP1/resolution 5, that the Assembly dispense with the secret ballot and elect the following 5 candidates by acclamation. For the Eastern European states, Mr. Urmet Lee, Estonia. For Latin American and Caribbean states, Ms. Ana Patricia Villalobos Arrieta from Costa Rica. For Western European and other states, Mr. Karl-Heinz Heller from Germany. Mr. Daniel MacDonald from United Kingdom of Great Britain and Northern Ireland, and Ms. Pascal Tomas Hernandez of Spain. Does the Assembly wish to elect the above-mentioned 5 candidates by acclamation for a 3-year term commencing on 1st January 26? I see no objection. It is so decided. I note that the 6th seat on the committee is allocated to the African group. In that, as regards that vacant seat to the African group, I understand that consultations have been going on since there are two candidates. And may I ask whether any outcome on these consultations has emerged? I don't see anyone requesting for the floor. I understand that consultations are thus still ongoing within this regional group in order to reach agreement on the candidate to be presented to the Assembly for election. I request the coordinator of the African group to keep me informed on developments regarding this matter. And in order to allow everybody to know, currently we have 2 candidates, Mr. M. Gilbert Raveloson de Madagascar and Philippe Neri Coulon-Nion from Burkina Faso. And as I mentioned, I request the coordinator of the African group to inform me during the course of this week whether a decision has been reached within the group. We shall thus return to agenda item 11 at a later plenary. Then we have a casual vacancy on the committee from the group of Eastern European states, which arose from resignation of Ms. Elena Sobkova from Slovakia on 7th of November 24. I wish to indicate that on 12th March 25, the Bureau fixed the nomination period to run from 17th March until 16th April 25. After 3 extensions of the nomination period, no nominations had been received. Therefore, on 17th July 25, the Bureau decided to reopen the nomination period for the casual vacancy allocated to the Eastern European group to run until 24th of August. And at the close of the nomination period, 1 candidate had been nominated. On the 8th of October 25, the Bureau, pursuant to resolution ICC-ASP1/resolution 5, decided to recommend that the Assembly dispense with the secret ballot and elect the following candidate by acclamation: Ms. Mateja Vranegigar Erman from Slovenia. Does the Assembly wish to elect the above-mentioned candidate by acclamation for the remainder of the term of the member who resigned, namely until 31st December 26? I see no objection. It is so decided. I congratulate Ms. Mateja Vranegigar Erman from Slovenia on her election to the Committee on Budget and Finance and wish her every success in fulfilling her important mandate. Then we have vacant seat pursuant to resolution ICC-ASP/22, resolution 8. As regards that 1 vacant seat on the committee allocated to the Eastern European group pursuant to resolution I mentioned on 12th March 25, the Bureau fixed the nomination period to run for 12 weeks from 2nd June to 24th August. At the end of that period, since no nominations had been received in accordance with resolution ICC-ASP/1/resolution 5, the nomination period was extended 3 times, ending on 20th October 25. Since no nominations were received for election to the seat allocated to the Eastern European group during the extended nomination period, the election for this seat will be held at the 25th session. I wish to recall that this additional seat was allocated to the Eastern European Group at the 22nd session by resolution ICC-ASP22/resolution 8, which deals with the expanded CBF. On behalf of the Assembly, I would also like to extend my appreciation to the outgoing members of the committee, Ms. Sarla Hail-Yusu from Sierra Leone and Mr. Klaus Stein from Germany for their committed service. And as I mentioned previously, we will revert to our consideration of agenda item 11 at a later stage this week. We turn now to agenda item 19, other matters. And first there we have election to fill a vacancy on the board of directors of the Trust Fund for Victims. I would like to indicate that this item was included under other matters since I was notified on the 28th of July 25 by the outgoing member, Ambassador Tarek Mohammad from Bangladesh, of his resignation effective December 25, several months after the provisional agenda for this session had been issued on 3rd April. The Bureau took thus a decision on the opening of the nomination period at its next meeting on 3rd September 25. And for this election, I wish to recall that the nomination period closed yesterday on 30th November. The Secretariat has informed me this morning that at the close of the nomination period, one candidate had been presented for election to the one seat allocated to the Asia-Pacific Group. In addition to 26 November 25, the Bureau authorized me to recommend that the Assembly dispense with the secret ballot and elect the candidate by acclamation if, at the close of the nomination period, the number of candidates corresponded to the number of vacant seats. Since this is the case, does the Assembly agree that we would proceed to elect a member of Board of Directors by acclamation? I will, of course, mention the name once I see that the Assembly agrees to do accordingly. I see no objection. The Assembly will now proceed to elect a member of the Board of Directors to fill the vacancy for Asia-Pacific Group that arose upon the resignation of Ambassador Tarek Mohammad, Bangladesh, effective December 25. Mr. Mohammad was elected at the 23rd session of the Assembly for a 4-year term commencing on 6th December 24. On the 3rd September 25, the Bureau fixed the nomination period to run for 12 weeks from 8th September to 30th November. And at the close of the nomination period, one candidate had been nominated for election. And he is Mr. Oh Won from Republic of Korea. Does the Assembly wish to elect the above-mentioned candidate by acclamation for the remainder of the term of Mr. Mohammad, namely until 5th of December 28? I see no objection. It is so decided. I think we have this every year on the first Monday that we will have this alarm telling us that it is 12 o'clock. Very timely. On behalf of the Assembly, I congratulate Mr. Oh Won on his election to the Board of Directors of the Trust Fund for Victims and wish him every success in the discharge of his important responsibilities towards the victims of the crimes within the jurisdiction of the court and their families. I also wish to extend my appreciation to the outgoing member of the board, Ambassador Tarek Mohammad, for his committed service to the Trust Fund for Victims. Distinguished delegates, we have concluded our business for the first plenary meeting. We will meet here at 15 hours sharp to begin the general debate. I wish to announce that the Credentials Committee will meet immediately following the adjournment of this meeting in the Colorado room. I wish you all a pleasant lunch break and see you back here at 15 hours.